Prologue: The Woman Who Came. Unnamed. Prologue: The Woman Who Came from Somewhere Better.
Gillian Rainey was, by any reasonable measure, the strangest constitutional scholar anyone had ever met.
She kept a small jar of soil on her desk, not for any practical reason, just because she liked being reminded that the ground was alive. She talked to plants, not in the way that slightly eccentric people talk to plants, as a joke or an affectation, but genuinely, the way you'd talk to a neighbor you passed every morning. She believed, and would tell you so plainly and without embarrassment, that everything visible was just source energy wearing a temporary costume, and that the costumes were considerably less important than most people thought. She also wore safety goggles pushed up on her forehead at almost all times. This had been perfectly normal where she came from. Here, it required occasional explanation. She had grown up in a world that had, over several generations, largely come to agree with her about the source energy part. Not the goggles. Those were just Gillian, the world she left behind. The universe Gillian came from had not arrived at its understanding easily or quickly. It had gone through its own version of the long struggle, the control systems, the manufactured scarcity, the hierarchy of who got to decide what everyone else was worth. But somewhere in its history, the people had done what people eventually do when the weight becomes unbearable. They had looked at the system clearly, called it what it was, rebuilt it from the foundation, and, over several generations of patient, unglamorous work, evolved past the need for the whole apparatus of artificial control. In Gillian's world, they called it the Great Untangling. History students learned about it the way students in other places learned about the fall of Rome, as a pivotal period of institutional collapse followed by something better. The Federal Reserve, in her world's history, had eventually been recognized for what it was: a private banking cartel granted governmental authority, dressed in public institution clothing. When that recognition became undeniable, and the documentation that made it undeniable became widely available, thanks in no small part to the early internet, the public conversation had shifted in a way that proved impossible to reverse. They called that system, in hindsight, the Matrix. Not as a film reference. The film came later, and the architects always privately suspected that someone in the know had helped write it. But as a technical term, a matrix, a framework within which everything else was embedded. The financial matrix. Once you saw it, you couldn't stop seeing it. Once enough people saw it, the thing became very difficult to maintain. By the time Gillian was born, nobody in her world charged anyone else for sunlight. Which brings us to what she had been working on the morning she found herself standing in an alternate dimension, still holding a grease-stained notebook, wearing safety goggles pushed up on her forehead, and staring at a city that looked disturbingly, uncomfortably, specifically familiar, the project she left behind. Gillian's research, the project that had consumed 7 years of her life before the dimensional event interrupted it rather dramatically, was built on a question that most people in her world of origin considered obvious, but that would have seemed radical in almost anywhere else. If the energy is already there, why are we manufacturing more of it and charging people for the transaction? Lightning had fascinated her since childhood. A single bolt carries enough electrical energy to power a home for a month. The Earth's atmosphere generates roughly 40 to 50 lightning strikes every second, continuously, without pause, without fuel, without a power plant, without a meter running. The ionosphere and the Earth's surface maintain a constant electrical potential difference, a voltage differential that Tesla had identified over a century before Gillian was born, and that her world had finally figured out how to harvest, practically. The system she was building when the dimensional rift opened was elegant in the way that good engineering always is. It didn't generate electricity. It collected what was already there. Atmospheric charge accumulation, resonance amplification through tuned antenna arrays, ground potential differential harvesting. The mathematics were clean. The early prototypes worked. The full-scale version would have provided continuous distributed electrical power to a community of several thousand, with no fuel cost, no emissions, no monthly bill, and no central point of control. She had been calibrating a resonance coil when the rift opened. She went through it because Gillian Rainey had never in her entire life been capable of leaving an interesting problem alone. She arrived in the alternate dimension still holding the notebook. The resonance coil, prototype, palm-sized, wrapped in copper wire that had taken her 3 weeks to wind at the correct gauge, came through with her, still faintly humming. She set it on the corner of every desk she subsequently occupied. It hummed there throughout everything that followed. She found the sound helpful. The goggles stayed on her forehead for 3 days before Dax finally pointed them out. "You're wearing your goggles," he said. "I'm always wearing my goggles." "We came through a dimensional rift. There's nothing to... never mind." "Thank you, Dax." Dax Reinhold, the man who brought the library. Dax Reinhold had been Gillian's assistant in their home universe for 6 years before the rift. He was, in almost every respect, her procedural opposite. Where she thought in webs and lightning bolt connections, he thought in timelines and document stacks. Where she saw patterns before she could name them, he named patterns after building comprehensive evidence that the pattern existed. Where she would walk into a room having already solved the problem and spend the meeting explaining the solution, he would walk in with 17 folders organized chronologically and a laptop. He had brought the laptop through the rift. This was, in retrospect, the most consequential thing that happened on the day of the dimensional event. More consequential than the event itself. Dax was, in the terminology of his home universe, a legal history obsessive. Not a lawyer, a historian. He had spent 12 years documenting, with the thoroughness of a man who genuinely found this interesting, the complete evolution of American constitutional law from ratification through the 20th century. He had a particular fixation on the period between 1870 and 1913, what he called the contested century, when the original constitutional framework was still largely intact, but the forces that would eventually capture it were gathering strength. His laptop contained the entirety of that research. Every Supreme Court decision, every congressional statute, every Constitutional Convention debate record, the full body of common law as American courts had developed it up to December 22, 1913. He had assembled it originally for a comparative legal history project. He had never imagined it would become operational intelligence. When the rift opened and he found himself standing next to Gillian in an alternate dimension that smelled like exhaust and institutional coffee, his first instinct was to check whether the laptop had survived the transit. It had. 92% battery. All files intact. "Dax," Gillian said, very quietly, looking at the city around them. "Do you recognize this?" He looked. He looked for a long time, and then, with the particular stillness of a man whose pattern recognition has just fired on something it wasn't prepared to find, he said, "I think this is us. I think this is where we came from. Before. Before the great untangling," she said. "Before the Matrix came down." They stood in the middle of a busy alternate dimension sidewalk and looked at a world their history books had described in academic language, now rendered in vivid, exhaust-scented, billboard-covered reality. "The laptop," Gillian said. 92%, Dax said. "All files intact." She looked at him. He looked at her. The goggles on her forehead caught the afternoon light. "Well," she said, "let's get to work. Part 1. Recognizing the Matrix. The online communities that saw it first. The architects had not arrived in the alternate dimension entirely without allies. They had not arrived with allies, exactly, but they had arrived in a world that was already generating them, in the chaotic, unglamorous, frequently embarrassing way that genuine insight tends to emerge before anyone with institutional authority is willing to acknowledge it. The internet in this alternate world was remarkable. Jillian spent her first week largely reading it, with the focused intensity of someone reviewing field data from a long-running experiment. Dax spent the same week building spreadsheets. What she found in the online communities, the forums, the chat groups, the conspiracy-minded websites that the respectable institutional press reflexively dismissed, was not what she'd expected. She had expected confusion. She had expected paranoid pattern matching, the kind that sees connections because it wants to, rather than because they're there. She found both of those things. She also found something else. People who had looked at the same documentation Dax carried on his laptop and arrived at the same conclusions, working entirely alone, without credentials, without institutional support, without anyone telling them their work was valid. A retired machinist in rural Ohio who had spent 7 years reading Federal Reserve statutes and had produced a hand-annotated copy of the Federal Reserve Act of 1913 that any constitutional lawyer would have found legally coherent. A former accountant in her 60s who had mapped on her dining room table using printed bank statements and a corkboard the ownership structure of 4 investment management firms she had noticed held significant positions across seemingly unrelated industries. A 29-year-old who had gone down what his family called a rabbit hole after losing his small business to what he described as regulatory capture, and who had produced, without legal training, a remarkably accurate description of the non-delegation doctrine problem and why it mattered. "They're doing the work," Jillian told Dax after the first week. "Without the library, without the precedents, without any of what we brought. They're doing it on instinct and stubbornness." "They're being called crazy for it," Dax said. "Our people were called crazy for it too. For a while." She set down her tablet and looked out the window of the small office they'd secured. Low rent, 3rd floor, view of a parking structure, and thought about what she knew about how the great untangling had actually begun in her own world. Not with a lawsuit. Not with a dramatic courtroom moment. It had begun with people in living rooms, talking to each other in the dark, comparing notes, discovering that what each of them had individually dismissed as personal paranoia was, in fact, documented institutional behavior. The internet had changed that in her world, made the living rooms global, made the note comparing instantaneous. She opened her notebook to a fresh page, drew a small sun in the corner, the rays arcing like lightning bolts, the way she always drew it, and wrote, "The people here have seen the shape of the thing. They just don't have the legal vocabulary to describe it in a way the courts are required to respond to. That's what we brought. That's the whole job." The first meeting. The architect's first public meeting in the alternate dimension drew 19 people to a borrowed conference room above a dry cleaning shop on a Tuesday evening. Jillian had not advertised it widely. She had posted in 3 of the online communities she'd identified as having the highest signal-to-noise ratio, the ones where people cited primary sources, and said simply that 2 legal researchers with an extensive pre-1913 case law library were interested in connecting with people who had been studying constitutional monetary law, and that the meeting was informational and without obligation. 19 people came. 3 of them drove more than 2 hours. 1 brought a binder. Jillian stood at the front of the room and looked at them for a moment before she began. They looked, she thought, like people who had been carrying something heavy for a long time and weren't sure whether to set it down yet in case it turned out this was another false alarm. "I want to start," she said, "by telling you what we're not. We're not going to tell you the law doesn't apply to you. We're not going to tell you that you can discharge your mortgage with a UCC filing. We're not going to help you claim you're a sovereign citizen who doesn't need a driver's license on some technical jurisdictional argument that will get you laughed out of court." Someone in the 3rd row relaxed visibly. Someone else in the 2nd row looked briefly disappointed. "What we're going to do," Jillian continued, is use the law, the actual law. The law as written in the Constitution, as interpreted by the Supreme Court in the century before the system you're describing was built, as it actually appears in the documents that are sitting on my colleague's laptop and are available to anyone who wants to read them. The courts won't hear it, said a man in the back. He said it the way people say things they've learned the hard way. Some of them won't, Jillian agreed. Some of them will. We're not trying to win everything at once. We're building a record. What does that mean, building a record? Dax leaned forward from where he was sitting at the side table. It means, he said, that every ruling we get, even the ones that go against us, contains the court's own explanation of why it claims authority. We collect those. We file them in the next case. We let the system document its own contradictions, in writing, on the public record, until the pattern becomes undeniable. There was a pause. That's chess, said the woman with the binder. She said it with something that sounded like recognition. Yes, said Jillian, it is exactly chess. The woman with the binder opened it and set it on the table. It was, Jillian saw, a meticulously organized collection of Federal Reserve Act annotations, cross-referenced against the Constitutional Convention debates. She had highlighted every place where the legislative record diverged from the constitutional text. I've been doing this alone for 4 years, the woman said. My name is Ruth. I used to be a librarian. Jillian reached across and turned a page, read for a moment, turned another. Ruth, she said, we've been looking for you. Part 2. What she saw. The alternate world did not shock Jillian the way it might have shocked someone who had never thought carefully about how control systems operate. She recognized the architecture immediately, not from personal experience, but from history. Her world had been through something like this. She had studied it, written her doctoral thesis on it. What she had not expected was how normalized it all was. How thoroughly the population had been taught to see the extraction mechanism as natural law. How genuinely most people believed that you were supposed to pay to exist, that the right to build a shelter on land you owned required a permit and an inspector and a fee. That the right to drive your own vehicle on roads your taxes had already paid for required a license issued by the same government collecting the taxes. That the right to hunt animals on public land belonging theoretically to all citizens, required an annual fee paid to a government agency. That the right to catch fish from a public waterway required a separate fee. That building a deck on your own home without asking permission first was a criminal act. That collecting rainwater that fell on your own property was, in some jurisdictions, not merely unlicensed, but actively illegal. Look familiar? No, of course not. Completely fictional. Carry on. She stood at the window of the architect's small office and watched the traffic on the street below and thought, every single person in that street is performing acts that their great-grandparents performed freely, for which they are now paying someone, usually the government, sometimes a corporation, often both, for the privilege of doing what their ancestors did as a matter of birthright. She opened her notebook to a fresh page, drew the sun, picked up her pen. The fees were not large, individually. That was rather the point. A government that charged you $1,000 to drive would face immediate revolt. A government that charges you $43 for a license plate, $62 for a hunting permit, $80 for a building inspection, and $200 for a contractor's license generates the same revenue and the same dependency, without ever triggering the moment when any individual charge feels worth fighting. Death by 1,000 small transactions. Each one normalized. Each one, if you looked closely at the pre-corruption legal framework, of uncertain constitutional foundation. She set down her pen. Let's see what the law actually says about all of this, she said to the notebook. Then she drew a small sun in the margin, rays like lightning bolts, and got to work. Part 3. Mapping the Corruption. The architects of remedy, Jillian, Dax, and the small team they had begun building from the online communities, arrived in the alternate dimension carrying something more powerful than weapons. They carried knowledge, a complete legal library of the United States as it existed on December 22, 1913. Every Supreme Court precedent, every congressional statute, every Constitutional Convention debate record, the full body of common law as American courts had developed it. What they found in the alternate world was familiar in shape but grotesque in substance. Here, the Federal Reserve Act had passed under circumstances that were nakedly problematic even by the standards of the era. The architects of this universe's central bank, a cartel of private banking families, had accomplished something remarkable. They had captured the legal education system. Every law school of consequence was endowed by the same financial interests. Every judge aspiring to federal appointment knew which philosophy kept careers alive and which ended them. Every statute touching money, commerce, and debt had been drafted by attorneys whose firms existed on banking retainer. The result, over a century, was a legal landscape that looked like law, had the grammar of law, wore the clothing of law, was cited by lawyers in briefs that used the word established with great frequency, but functioned in practice as a mechanism of permanent extraction. Any resemblance to actual systems is entirely coincidental. Probably. Jillian laid the problem out on the first night in the borrowed conference room with Ruth's binder open on the table beside Dax's laptop and 17 other people leaning forward in folding chairs. "There are 4 layers," she said, spreading documents across the table. "You cannot attack the top layer without understanding what's holding it up. And you cannot hold it up without understanding what's holding that up. We're going all the way to the foundation." She wrote on the whiteboard, "Layer 1, the money itself." In plain terms, they made money out of debt. Every dollar that existed in this alternate world was borrowed into existence, which meant every dollar came with interest attached. But here's the trap. The money to pay that interest was never created. So the only way to pay off old debt was to borrow new money, which created new debt, which required new borrowing. Forever. It was a wheel that could never stop spinning. And the people who owned the wheel collected a toll every time it turned. The alternate Federal Reserve had been granted, through carefully drafted statutory language, the power to issue currency as debt rather than as a representation of existing value. Every dollar in circulation was borrowed into existence, carrying an interest obligation that could never be fully retired because the money to pay that interest didn't exist until more was borrowed. The system required perpetual expansion simply to function. Ingenious, really, if you have the kind of mind that finds self-perpetuating extraction ingenious. Completely unlike any monetary system you might be familiar with in your daily life. We cannot stress this enough. Layer 2, the adhesion contracts. In plain terms, people were signed into legal agreements they didn't know they were signing. And those agreements, the corrupt system claimed, meant people had voluntarily given up rights they didn't know they had. You signed up for a benefit, a license, a registration, a program, and buried in the legal fine print was language that said you were now operating under a different set of rules. Rules that were considerably more convenient for the people running the system. Citizens in this world had been enrolled, largely without informed consent, in a web of contracts, Social Security enrollment, driver's licensing, business registration, each of which, under the corrupt system's interpretation, operated as a voluntary submission to statutory jurisdiction rather than constitutional jurisdiction. The corrupt courts treated these as waivers of common law rights. "How do they get away with calling it voluntary?" said the man from the back row. His name was Gerald, former small business owner, 2-hour drive. "When not signing means you can't work, can't drive, can't open a bank account?" "Excellent question," said Jillian. Write it down. That question is the foundation of approximately 40% of what we're going to file over the next several years. Layer 3, the statutory maze. In plain terms, they made so many rules that nobody could keep track of them all, and then enforced those rules selectively, against people who threatened the system. While the large, well-connected players who'd helped write the rules operated without meaningful consequence. The rules weren't really about order. They were about control. Specifically, control of who got to compete and who didn't. Hundreds of thousands of administrative regulations carried criminal and civil penalties, enforced by agencies whose officers were appointed by, and ultimately answerable to, the financial interests that had funded the political campaigns that won the elections that staffed the agencies. And speaking of those campaigns, the alternate world's elected officials, the elected officials, whose selection had been substantially determined by institutional campaign financing before a single vote was cast, had, over time, become almost entirely dependent on that institutional funding to run competitive campaigns. What a coincidence, then, that the institutions funding those campaigns tended to thrive under the regulations the officials subsequently enacted. Pure market forces at work. Nothing to see here. Seems like we've seen this before. But no. Fictional universe. Different situation entirely. Layer 4. The educational capture. Most devastatingly, the population had been taught, in schools funded by the same interests, that this system was the law, that the current arrangement was the only possible arrangement, that questioning it was fringe, that the Constitution was a living document that meant whatever current institutional power said it meant, that the pre-1913 precedents were quaint historical artifacts rather than binding legal authority. Jillian had a phrase for this in her notebook. Manufacturing the floor beneath the cage so the birds don't notice the bars. Margin note, Jillian Rainey. She set down her pen. We don't fight this with anger. We don't fight it with protests alone or outrage or the hope that someone in authority will suddenly develop a conscience. We fight it with standing, procedure, and precedent. She looked around the room at 19 people who had driven from various distances to a borrowed conference room above a dry cleaning shop to hear exactly this. And we have a library, she said, that they don't know exists. Dax looked up from his laptop. You're smiling. I always smile when I can see the whole board, she said. Part 4, the Constitutional Foundation. The first move was establishing what the law actually said. In plain terms, before you can prove someone is cheating, you have to establish what the rules actually are. Jillian's first job was to put the original rulebook on the table, publicly, officially, in a format the courts couldn't ignore, and ask, given that these are the rules, can anyone explain how the current system is legal? The architects began publishing the key pre-1913 precedents, not as argument, but as primary source documentation, available to anyone, searchable, free. Ruth, former librarian, managed the archive with the quiet ferocity of someone who had waited 4 years for exactly this purpose. The cornerstone was Hepburn versus Griswold, 1870, in which the Supreme Court had held that Congress could not make paper money legal tender for pre-existing debts, because doing so violated the spirit of the Constitution's contract protections. Though later partially reversed, the case established a principle that monetary legislation has constitutional limits, that Congress cannot simply declare by statute that a thing means the opposite of what the constitutional text says. More powerful still was Bronson versus Rhodes, 1869, which had held that a contract specifying payment in gold coin could not be satisfied with paper currency. That the parties' actual agreement controlled, not the government's preferred medium of exchange. The architects published these alongside the full text of Article 1, Sections 8 and 10, and the Fifth Amendment's Takings Clause. They asked a simple public question. If the Constitution means what it says, and these cases were decided by the highest court in the land and never constitutionally overturned, on what legal basis does the current system operate? The corrupt system's defenders had an answer: a century of subsequent case law. The architects were ready for that too. The first piece was on the board. Another piece moved. The board was taking shape. Jillian's Notebook, Part 5, Attacking the Legitimacy of Captured Precedent. Here Jillian deployed the most elegant argument in their arsenal. In plain terms, imagine someone builds a house on land they don't legally own. Then they build a second floor on that house, then a third. Then they point to the third floor and say, "Look how established this structure is. It's been here for decades. You can't tear it down now." Jillian's argument was simple. It doesn't matter how many floors you add. If the foundation is illegitimate, the whole building is illegitimate. Every law built on top of an unconstitutional law is just as unconstitutional as the original, no matter how long it's been there. Under established legal theory, specifically the principle articulated in Norton v. Shelby County, 1886, an unconstitutional act is void from its inception. Not merely voidable, void, as though it never existed. The court had written that an unconstitutional act confers no rights, imposes no duties, and affords no protection. The architect's argument was surgical. If the original enabling legislation for this world's Federal Reserve System was unconstitutional, and they had the pre-1913 legal framework to demonstrate precisely why, then every statute built upon that foundation was built upon nothing. The century of precedent citing those statutes was, legally speaking, a tower of citations resting on air. They filed their first brief not to overturn the Federal Reserve. Too large a target, too early in the game, and Jillian never argued more than she had to prove. But to challenge a single administrative penalty issued against a small farmer who had attempted to conduct commerce in gold coin, citing Bronson versus Rhodes and the explicit constitutional text. The courtroom for the first hearing was not particularly dramatic. Federal district courts rarely are. There was institutional carpeting of a color that suggested it had been selected by someone who never had to look at it. The government attorney was efficient and not unkind. "Your Honor," he said, "the challenge raised by counsel goes to the constitutionality of federal monetary policy, a matter settled by over a century of precedent and committed to congressional authority. We move for dismissal for lack of jurisdiction." Jillian rose. She was, when arguing, very still. She had noticed long ago that stillness made people listen harder, that the impulse to fill silence with words was so strong in most people that a speaker who resisted it acquired a strange authority. "Your Honor," she said, "counsel has cited a century of precedent. We don't dispute that those precedents exist. We would like to ask one question. Do any of them address the specific constitutional authority or lack of authority under Article 1, Section 10, for the conversion of private contractual obligations from gold coin to Federal Reserve notes? Not assume it. Not rely on the General Commerce Clause. Address it." A pause. "We'll brief that, Your Honor," the government attorney said. "I thought so," said Jillian, and sat down. The corrupt system's response, when the brief arrived, was exactly what the architects had expected: jurisdictional dismissal. The court ruled the farmer had no standing. The challenge was non-justiciable. The matter was committed to agency discretion. Jillian read the ruling carefully, read it again, made a small notation in the margin of her copy. She had wanted that ruling in writing, and now it was. "They dismissed it," Gerald said at the next meeting. He sounded discouraged. "Yes," said Jillian. "Exactly as planned." How is losing exactly as planned? Because now I have a written ruling from a federal court explaining, in the court's own words, why it believes it doesn't have to examine the constitutional question, which means I can file that ruling in the next case as evidence of a pattern of judicial avoidance, and in the case after that. And eventually, I'll have enough of those rulings that an appellate court will have to explain, in writing, why the pattern itself doesn't constitute a due process problem. Gerald considered this. How many cases are we talking about? As many as it takes, she said. Chess is a long game, Gerald. The trap was set. Jillian's Notebook, Part 6, Building the Record. The most important legal victories, Dax told the group one evening, spreading his folder organization across 3 folding tables in a way that suggested he had given this considerable thought, are not won in the first courtroom. They're won by building a record that makes the final courtroom inevitable. In plain terms, every time the corrupt courts dismissed their cases, the architects appealed. Every appeal produced a written ruling. Every ruling contained the system's own explanation of why it claimed the authority it was exercising. Jillian collected those explanations the way a scientist collects data, because eventually, the pattern of those explanations would itself become the evidence. She was letting the system indict itself, in writing, one ruling at a time. They recruited plaintiffs carefully, people with clean records, sympathetic facts, and documented damages. People the system had genuinely harmed in ways the system's own documents could confirm. A retired schoolteacher whose savings had been methodically inflated away over 30 years. She had done nothing wrong, saved diligently, followed the conventional wisdom, and arrived at retirement to find that what she'd accumulated bought approximately 40% of what the same dollars would have purchased when she started saving. She hadn't lost money. The money had lost meaning. Something had been taken from her, quietly, without her consent, without compensation. The question was whether that something had a constitutional name. A small business owner whose regulatory compliance costs had risen by 300% in 7 years, driven largely by rules drafted by a standards organization whose governing board was composed almost entirely of representatives from the large corporations his business competed against. The rules always, somehow, fell more heavily on small operators than large ones. The large ones had helped write them, which might explain the pattern. Seems like we've seen this before. But no. Fictional. Completely different situation. A family farmer who had tried to access credit markets to expand and found that the only available financing came through a government-chartered entity whose lending criteria were designed in ways too specific to be accidental, to favor the large-scale industrial operations that had displaced his neighbors over the previous 30 years. Each case was filed with meticulous citation to pre-1913 precedent. Each brief explained, in plain English alongside the legal argument, exactly what the constitutional text said and what the pre-corruption cases had held. Dax organized the filings chronologically and cross-referenced every case to the database. Ruth ran the public archive. Gerald, who had turned out to have a remarkable eye for ownership structures, began mapping who owned what. Making the invisible legible, Dax said, every time Gerald produced a new ownership chart. It was, by this point, a running phrase. The team had adopted it as something between a motto and a verb. To Dax, something meant to make visible what had been deliberately hidden in plain sight through complexity. They were not trying to win immediately. They were building a library of the system's own contradictions. And Jillian was cataloging everyone with the quiet precision of someone who knows exactly what the final experiment will prove and is simply, patiently, gathering the last data points. Another piece moved. The board was taking shape. Jillian's Notebook, Part 7, The Common Law Restoration Argument. The deepest layer of the architect's strategy rested on a distinction most citizens of the alternate world had never been taught. In plain terms, there are 2 kinds of law in the American tradition. The first kind, common law, is the accumulated wisdom of centuries of actual disputes between real people. It protects your fundamental rights to your property, your contracts, and your person. And those rights exist whether or not any legislature has ever passed a law about them. The second kind, statutory law, is what legislatures create. Statutory law is entirely legitimate when it operates within its proper lane. It becomes illegitimate when it tries to eliminate or override the first kind. What the corrupt system had done, over decades, was use statutory law to quietly reclassify common law rights as privileges, and then charge people fees to get back a diminished version of what they had always had, for free. The corrupt system had replaced common law property rights with regulatory frameworks that required citizens to obtain permission and pay for that permission from government agencies to do things their great-grandparents had done without a second thought. Build a home on your own land, dig a well on your own property, sell the vegetables you grew in your own garden, teach your own children, start a business, travel freely, collect the rain that fell on your own roof. Each of these, in the original common law framework, was a right, not a privilege, not a licensed activity, not a thing requiring advance government approval. A right, yours, by birthright, by the common law tradition, by the constitutional framework that was supposed to protect it. In the captured system, each had been quietly reclassified as a privilege, available upon application, subject to approval, revocable at agency discretion, and carrying a fee. The reclassification had happened gradually, incrementally, with each individual step too small to trigger decisive resistance. Death by 1,000 small transactions, Dax said, the first time Jillian mapped it on the whiteboard. Each one normalized. Each one looked at individually, Jillian said, arguably reasonable. It's only when you see the whole map that the direction becomes clear. The architects attacked this directly, citing Marbury versus Madison, 1803, the most foundational case in American constitutional law, the one that established the very principle of judicial review. A law repugnant to the Constitution is void. They did not argue that all regulation was unlawful. Jillian was precise about this in every brief, because she knew that the argument could be caricatured as fringe if she let it be imprecise. She argued, carefully, surgically, with specific citation, that this specific regulation, in this specific application, exceeded the constitutional grant of power and extinguished a common law right without due process of law. The precision was the point. Never argue more than you have to prove. Argue the case in front of you. Win that. File the next one. Chess, not checkers. Jillian's Notebook. Part 8. The Turning Point. The turning point came not in a federal court, but in a state appellate court, before a 3-judge panel that had reached the bench through a political path outside the banking cartel's usual sphere of influence. This was not an accident. Jillian had spent 4 months identifying exactly this court. In plain terms, sometimes you find an honest referee. The architects had been building toward this moment, filing cases, losing, appealing, losing again, accumulating a record. Specifically so that when they found an honest court, they arrived with years of documented evidence and a fully developed argument rather than a half-formed theory. The honest judges didn't change what the law said. They just read what it actually said and applied it. The case was deceptively simple. A family had contracted to sell land, specifying payment in what the contract called lawful money of the United States, a standard phrase with a specific legal meaning under pre-1913 precedent, lawful money, gold or silver coin, as contemplated by Article 1, Section 10 of the Constitution. The buyer had tendered Federal Reserve notes. The family refused them. The lower courts had ruled for the buyer. On appeal, Jillian filed a brief that walked the 3-judge panel through the full history. The constitutional text, the ratification debates, the early Supreme Court cases, the specific meaning of lawful money as American courts had understood it for over a century before 1913. And then, step by carefully documented step, the statutory changes that had purported to alter that meaning. She asked one question: did Congress have constitutional authority, under Article 1, to change the meaning of lawful money as used in a private contract between private citizens? The oral argument was 23 minutes. Judge Carver, the presiding judge, leaned forward at minute 11. Counsel, are you arguing that the legal tender acts of the 1860s were unconstitutionally applied to private contractual obligations, or that the subsequent statutory framework built on those acts is similarly suspect? Both, Your Honor, in sequence. But for today's purposes, the court need only reach the narrower question: whether the private party's contractual specification of the medium of payment is enforceable as written under Bronson v. Rhodes and the constitutional text, without the court needing to address the broader validity of the Federal Reserve framework. I have tried, she said, with a slight smile, to give the court the shortest road to the right answer. We appreciate that, said Judge Carver. The appellate court ruled for the family. 3-0. It was a narrow ruling, one state, one contractual phrase, one family's land. But it was on the record. It cited Bronson v. Rhodes. It cited the constitutional text. It acknowledged that the original meaning of lawful money was a specific thing, and that private parties had the right to contract for it. The corrupt system immediately appealed to the state Supreme Court. Jillian had been counting on that too. She closed her notebook, tapped the cover twice with one finger, and said nothing for a moment. The resonance coil hummed quietly from the corner of her desk, doing what it had always done, collecting what was already there. They just handed us the venue we needed, Dax said. I know, she said. I know. The trap had closed. Jillian's Notebook, Part 9, The Architecture of the Final Argument. Before the state Supreme Court, Jillian delivered the consolidated argument the architects had been building for years. The courtroom was full. The press was present. In the back rows, in various configurations of professional clothing and barely suppressed anxiety, were attorneys representing the financial interests that understood precisely what was at stake. She did not attack the Federal Reserve directly. She did not argue conspiracy, though the documentation for one was substantial and Dax had organized it into 17 folders. She argued law. Just law. Calmly, precisely, with the quiet confidence of someone who has been in the room with the answer for a very long time and is only now being given the microphone. The 5-part argument: first, the Constitution means what it said when it was written, not what powerful institutions currently find convenient. The founders were not writing poetry. They were writing a legal document, drawing on specific legal traditions, with specific legal words that had specific legal meanings. The document doesn't change because the team that's winning would prefer different rules. In plain terms, the rulebook doesn't change just because the team currently winning prefers different rules. If they want different rules, they have to use the amendment process, which exists, which they have not used, because they couldn't get the votes, which tells you something. Second, Article 1. Section 10 provides, plainly, without qualification, that no state shall make anything but gold and silver coin legal tender. This was not poetry. The founders had personally watched paper money inflate into worthlessness during the Revolutionary War. This clause was written by people who had lived the consequence of ignoring it. In plain terms, they were very specifically trying to prevent the thing that subsequently happened. It's almost as though they knew what they were writing. Third, the Fifth Amendment prohibits the government from taking private property without just compensation. Systematic inflation, the reduction of purchasing power through money creation, transfers wealth from savers to debtors without consent and without compensation. Something has been taken. The question is whether that taking is constitutional. The architect's argument was that it is not. In plain terms, if your dollar buys less every year because someone is printing more dollars, something has been taken from you. Not through theft in the conventional sense, through a process so gradual and so normalized that most people don't recognize it as the taking it is. The Constitution has a clause for that. Fourth, Congress cannot hand its lawmaking power to an agency and then walk away. The non-delegation doctrine, recognized in Field versus Clark, 1892, and J.W. Hampton Jr. and Company versus United States, 1928, requires that any delegation come with clear, intelligible guidelines. Do whatever you think is best for the economy is not a guideline. It is a blank check. And the people cashing it are the same people who wrote it. Fifth, under Norton versus Shelby County, unconstitutional acts are void from the beginning. Every law built on a void foundation is itself void. The court was not being asked to overturn a century of precedent. It was being asked to recognize that the precedent had never been valid, and that the distinction matters. In plain terms, you cannot grandfather in fraud simply because it is old fraud. The age of the deception is not a defense. She closed her argument and sat down. Dax leaned over and said, very quietly, "That's the whole board." Jillian looked out the courtroom window. The afternoon light came through at a low angle and caught the dust motes turning slowly in the air, and for a moment she saw them the way she always saw everything. Just energy, just source, wearing its temporary costume, moving according to its nature. The same energy that moved through lightning. The same energy she had been trying, in another universe, to find a way to give freely to people who were being charged for inferior substitutes. It always was, she said. Epilogue. What justice requires. The architects knew they might not win in their lifetimes. Constitutional restoration, when it comes slowly, through shifted public understanding, through the accumulation of record, through the patient work of establishing, case by case, what the law actually says and what it has always actually said. But they also knew something the corrupt system's architects had always known and feared. The law, honestly applied, is the most powerful force in a constitutional republic. It was why the banking cartel had worked so hard to capture legal education, to staff the courts, to make the population believe that what existed was inevitable and natural and had always been thus. It wasn't inevitable. It was constructed, and anything constructed by human hands can be reconstructed by human hands, especially when those hands are carrying the original blueprints. In the online communities, the forums and chat groups where people had been working alone, in the dark, without credentials or institutional backing, for years before the architects arrived, something was shifting. The architects' published briefs were being read. The citations were being checked. The pre-1913 precedents were being downloaded and annotated by people who had never gone to law school, and who were, as a result, reading them without having been taught what they were supposed to conclude. This, in Jillian's experience, was how it began. Not in courtrooms, in living rooms, in borrowed conference rooms above dry cleaning shops, in the careful, stubborn, unglamorous work of people who had decided that the fact that something was wrong was a sufficient reason to do something about it. Jillian packed up her files each evening and set her jar of soil on the corner of her desk and sat for a few minutes in the particular quality of quiet she had practiced since childhood. The quiet in which, if you paid attention, you could feel the aliveness underneath everything. The energy in the walls, in the air, in the documents stacked on every surface. The same energy that moved through lightning. The same energy her resonance coil was quietly, patiently collecting from what was already there. Not manufacturing it, not generating it by force, not charging per kilowatt hour, just gathering what had always been present, just making it available. The parallel was not lost on her. The architects kept filing, kept publishing, kept making the invisible legible. One case at a time, one citizen at a time, one honest judge at a time. Jillian's Journal, Closing Entry, Part 1. The system was built in the dark, not quickly, slowly, over generations, with patience and with the understanding that people will accept almost anything if you introduce it incrementally and surround it with enough complexity that tracing the logic from cause to effect requires more sustained attention than daily survival tends to allow. We brought the light, not a new light, the same light that was here before they built the walls around it. The cases, the constitutional text, the debates of the people who wrote the rules and whose intent is, legally, part of what the rules mean. Ruth had been doing this alone for 4 years. Gerald lost his business and then spent 2 years in forums being told he was a conspiracy theorist. The retired machinist in Ohio has hand-annotated documents that are legally coherent and has been laughed at for years by people who have never read them. They were right. They just didn't have the language the courts are required to respond to. That's what we brought. The system was built in the dark. We intend to finish our work in the light. J.R. To be continued. Next. The architects turn their attention to the medical-pharmaceutical complex. Jim Carter wants to play parlor guitar on Tuesday afternoons. That turns out to be a constitutional question. A note on legal accuracy. The cases cited in this story, Hepburn versus Griswold, 1870, Bronson versus Rhodes, 1869, Norton versus Shelby County, 1886, Marbury versus Madison, 1803, Gibbons versus Ogden, 1824, McCulloch versus Maryland, 1819, Field versus Clark, 1892, and J.W. Hampton, Jr. and Company versus United States, 1928, are real Supreme Court decisions with the holdings described. The constitutional provisions referenced are quoted accurately. The atmospheric electricity concepts reflect real physics, including Tesla's documented work on the Earth ionosphere electrical system. This story presents these as fictional legal strategy in a speculative setting. It is not legal advice, and real constitutional challenges require licensed counsel familiar with current controlling precedent in the relevant jurisdiction. Series Disclaimer. This is a work of speculative fiction set in an alternate dimension. Any resemblance to actual monetary systems, regulatory frameworks, pharmaceutical industry practices, agricultural policy, automotive market structures, or real estate acquisition strategies is entirely coincidental. Probably. All legal cases and statutes cited are real and accurately described. This is not legal advice. Real challenges to real systems require licensed counsel familiar with controlling law in the relevant jurisdiction.